Welcome to Brief Encounters. Last time, we brought in two DC labor and employment attorneys, Rachel Green, associate at Katz Banks Kumin, and Deontay D. Sylvertooth of Counsel at Ogletree Deakins, to discuss the District of Columbia's new ban on non-competes. DC's ban on non-compete agreements Amendment Act of 2020 was one of the country's broadest laws curtailing the use of non-compete agreements. Since its inception, the ban has been subject to criticism, which has led to several extensions of its applicability date. In part one of our podcast, we discussed several proposed amendments. However, on the day after we recorded our podcast, July 12, 2022, the DC Council finalized their amendments and passed the Non-Compete Clarification Amendment Act of 2022 to modify the ban. Mayor Muriel Bowser officially signed the Clarification Act on July 27th, and the act is still set to be applicable on October 1st, 2022. I'm joined again with Rachel and Deontay to discuss the Clarification Amendment and how it's impacted the existing ban. Thank you both for being here.
Thanks, Olive. Glad to be here.
Thanks, Olive. Glad to be here again.
Great to have you both. Let's start with Rachel. Can you remind our listeners about how we got here? What is the Ban on Non-Compete Agreements Act of 2020, and what were its most significant provisions?
Sure. So just to clarify, this will be what the act was before the recent amendments, which I know we'll just discuss momentarily. So before these amendments, DC's new non-compete ban was one of, if not the broadest bans on non-competes in the country. And so before these amendments, the law prohibits DC employers from requiring or requesting that an employee sign an agreement that included a non-compete provision. And there were limited exceptions for what employees were exempt from this protection. A non-compete provision was defined essentially as one that prohibits the employee from being either simultaneously or subsequently employed by another person or operating the employee's own business. And again, pre-amendments, the law included a mostly exception-free protection of moonlighting. And so in other words, employers basically could not restrict an employee from working for another while they were currently employed by that employer. And so an employee was pretty free to work two jobs at once. There were very limited exceptions to who was protected under this old law. Also pre-amendments, the DC ban on non-competes did not include a salary threshold for almost all employees. There were some medical providers that did have a salary threshold and other limitations. It was $250,000 total compensation for medical specialists, which was defined basically as those engaged in the delivery of medical services, holding a license to practice medicine, working as a physician, those who have completed medical residency, and again, who have that $250K annual total compensation. So that was already in the law, but otherwise there was not a salary threshold. So I'm just kind of foreshadowing that that's a change. And overall, this ban benefited employees greatly. It protected their ability to seek future and even simultaneous employment in the same field where they were currently employed, which obviously opens doors for employees to more easily and efficiently jump from one position to another, hopefully a better position, without having to wait under a non-compete for potentially years for the agreement to expire.
Thank you, Rachel. Deontay, what were some of the provisions that some employers in the DC business community were concerned about?
So I think Rachel did a very good job of encapsulating what the law was pre this current amendment that we'll be talking about shortly. And in essence, I think one of the things that she indicated was that, employees were free to jump where they wanted to. I'm paraphrasing, that's not the term that she used. But certainly that is certainly an issue for employers because that law in and of itself essentially placed a stranglehold on employers to engage in negotiation with employees about entering a non-compete, because sometimes, let me step back and say that the non-compete law as it was virtually didn't allow a non-compete period, right? When we say few exceptions, there was really no exception. The only exception were medical providers, babysitters who sat in someone's home, and someone who volunteered for no pay, and then an individual who was elected into the office. So those are the only carve-outs that was in the previous law. So it essentially stranglehold employers from allowing them to engage in typical negotiations in the sense of a non-compete. It also prohibited them from moonlighting, having moonlighting policies. And sometimes employers had these policies not because they just didn't want someone to work for another employer or work for themselves, but a lot of it was regulated for safety purposes to ensure that individuals had enough time to sleep before they come in into work and engage in the business that was related to that particular employer, with the understanding that things that they were working on also could potentially impact consumers. So it was important to ensure that individuals were well rested and prepared when they came to work. And so the law, as it was prior to this amendment that we're talking about, essentially prevented employers from regulating that aspect. And employers have been regulating from a moonlighting perspective for years. So it took that away from them.
Thank you both for that important recap. So during our last podcast, as I mentioned before, we discussed several different amendments that the DC Council was thinking about. We discussed Council Member Alyssa Silverman's amendments and Council Member Brooke Pinto's amendments to address the different concerns of the business community. Councilmember Pinto's revisions have ultimately prevailed and are reflected in the Clarification Act. Rachel, can you tell us about some of the new or updated provisions in the Clarification Act? And can you provide some of your thoughts as maybe a plaintiff side attorney as well?
Happy to, Olive. I'll first note that the name of this Amendment Act is a bit misleading. Calling it the Non-Compete Clarification Amendment Act makes it sound like the amendment is merely a clarification, but the amendment significantly erodes the protections for employees that were present in the original act, and so it does not merely clarify. So with that note, a few of the examples of changes that are likely harmful for employees. One, as I foreshadowed a little bit earlier, explaining what the act before the amendment was like, there is now a salary threshold. And so non-competes are permissible for highly compensated employees, as the act defines it. So basically, people who are total compensation of $150,000 a year or more, those individuals, those employees can be subject to non-competes. And the act does allow that, after a certain year annually, that compensation will raise, and that's to reflect the impact of inflation and other economic concerns. But in general, the act no longer protects employees who are compensated over $150,000 a year. And I'll note that there are not a lot of individuals who are paid this much in DC and across the United States. It's a relatively small percentage of the population, but this is a change. The act now does permit non-competes for these employees, and so it does limit their flexibility in finding future employment, period. It's a limitation on those folks. One of the other negative changes impacting employees is that the amendments include additional carve-outs for what does and does not constitute a non-compete. So one example that's a little bit of a shift is the act says that a non-compete does not include language that restricts an employee from disclosing, using, selling, or accessing the employer's confidential or proprietary information. So I'll note that I suspect, I'm obviously not one of the lawmakers, but I suspect this is one of the reasons why the amendment was called a clarification amendment, because I suspect that the lawmakers wanted to clarify that employers are allowed to restrict their employees from running off essentially with their confidential or proprietary information. But respectfully, as a practitioner in this field, employees were not previously permitted to do that. There are other protections and other laws that prevent employees from running off, using, accessing employers' confidential or proprietary information. So this is not a necessary clarification. And furthermore, there is a broad definition of confidential employer information embedded into the act. It basically says confidential employer information means information owned or possessed by the employer that is not available to the general public, and that the employer has taken reasonable steps to ensure is protected from improper disclosure. So this, without judicial input and additional court guidance, is a very broad definition of confidential employer information. So as a plaintiff side attorney, I'm concerned about how this could unfairly prohibit employees from sharing information that might not be extremely necessary for employers to protect. So that's one thing I want to flag. And I know I've been going on for a while, but another thing I also am concerned about is with these amendments, non-competes no longer include language that prohibits moonlighting under certain circumstances. And some of these circumstances are if an employer, quote, reasonably believes that engaging in simultaneous employment will result in disclosure of the employer's confidential or proprietary information, the employer is allowed to prohibit it. Or if the employer reasonably believes that moonlighting will pose a conflict of interest, which again, that's a broad range. What constitutes a conflict of interest? How is that defined? How are courts going to define that? That's something I'm concerned about. And then the final potential creep and expansion I'm worried about is this employer, if an employer reasonably believes that moonlighting will constitute a conflict of commitment if the employee is employed by an institution of higher education, there is a definition of conflict of commitment within the act, but on the whole, these multiple expansions of what is now excluded from a non-compete, those are all concerning to a plaintiff's side, employee side, attorney, because there is so much room for creep and expansion in that area and expansion of the definition of what does not count as a non-compete, which at the end of the day means that employers are permitted to prohibit employees from competing, potentially competing with them by seeking better employment at a comparable place. I'll stop there, but I do have many more thoughts.
Deontay, I would love to get your thoughts, especially as an attorney from the defendant side. What are your thoughts on the clarification amendment? And perhaps do you have any thoughts on the carve out for highly compensated employees and expansions on moonlighting prohibitions that Rachel just talked about?
Yes, thank you for allowing me the opportunity to highlight some of the great things that I like about this Clarification Amendment Act. But let me just start off by saying, I think it's a sensible measure what the DC Council did in regards to this particular amendment. And I think it strikes the right balance, right? So let's talk about some of those balances that it strikes. It harmonizes, for instance, the definition of a covered employee to be consistent with some of the other DC laws, such as DC FMLA, right? You have to be working in the district for about 50% of your time, or at least giving substantial work to the district 50% of the time. The previous act just basically said, if you receive $1 from someone, you were covered. It doesn't matter where you worked, how long you worked in the district. So it struck a sensible balance in that sense. I do think in regards to the salary threshold for the highly compensated employee, I think it's important for employers to know that it's not the salary itself, right? It's a host of things that can aggregate to the $150,000. It can be the hourly wages. It can include the salary. It can include bonuses or cash incentives. It includes commissions, overtime premium, vested stock, RSUs, or other payments that are regularly or irregularly given. But the beauty, I think, of this particular highly compensated aspect is that it's if they reasonably expect that they would make that threshold, right? So it doesn't mean that you need to know day one this person is going to be making $150,000 in total, but the expectation is that they will reach that threshold because of bonuses and things of that nature. And you can look at the preceding 12 months prior to the time that the individual is expected to enter into the non-compete agreement to aggregate to the $150,000 to show that they meet the threshold for highly compensated employee. Another thing that I think that's important in the sense of that the clarification does is that to the points that Rachel raised as troublesome, I think they're great, right? And some of that is that it doesn't blindly refuse to accept any non-compete, but it allowed a non-compete to be between a seller and a buyer, because that makes sense. If a seller is selling his or her business and a buyer is buying it, they don't want that same buyer to be competing with a business that they just purchased. It allows provisions and policies that protect an employee's confidential information. And if there is a concern that allowing an individual to work for another employee or him or herself would create a situation where no matter what they do, their position is so integral to the organization that the use of confidential proprietary information almost is unseverable, then you can identify that as a policy based upon the reasonable belief that that information will be disclosed. So that's something that an employer can use. And I think it's beneficial for employees as well as plans that are long-term incentives. So employers identify compensation packages that include stocks that are going to vest in the future and things of that nature. So it's important that they are allowed to use a non-compete in order to deal with those particular issues. I will say this, I do have quite a few, but I'm going to not take too much of the time. But I do want to say when it comes to individuals who are highly compensated individuals, the law requires, or the clarification requires, that they receive a particular notice. It also requires that that particular non-compete, identify the functional area in which the non-compete will apply, the geographical area in which the non-compete will apply, and the time frame. It limits the time frame. If they're not a doctor or a medical specialist, the non-compete can only last 365 days. I think that's important because when you look at case law related to whether or not a non-compete is valid or invalid, oftentimes it focuses on the function, the geographic, and the time. And so what this law attempts to do is alleviate the stress of litigating the non-compete provision if in fact it qualifies and stand up and be valid in relation to what the law requires. So, and as it relates to those policies that, are carve outs, it requires the employer to communicate to employees who are covered employees that this policy is in place, because it requires them to give notice to them 30 days after October the 1st, 30 days after they start their employment, and anytime those policy changes. So it allows a check and balance so that employees can see what the policy is, what they're doing, and whether or not it holds up to the law. So I think it's a sensible clarification. So I like the law.
So Deontay, is it more of a clarification, true to its name?
Is it really a clarification? Sure. I think the right clarification. That's all I would like to say.
That's great. Rachel, I would love to give you some space to respond to some of Deontay's points or add additional thoughts that you have on the Clarification Act.
Sure. I think the only addition I'd have, because I think I highlighted some of the most concerning things from a plaintiff and employee side, there are some neutral changes that I suppose perhaps could qualify as clarifications. For example, Deontay mentioned this 30-day requirement for notification. There's this must be in writing, provided at least 14 days before the employee starts work, or 14 days before expected to sign the agreement. And those types of, quote, clarifications are helpful, I would argue, for both sides, because it provides a set of expectations for both employers and employees for the timing of when individuals are supposed to be informed of their rights or lack of rights, and especially if there's going to be a change in the policy. So it's good to have those types of clarifications in the law. And there are also limitations on the non-competes in that they require a non-compete to contain a clear geographic limitation, which is good to have that specified in the law. For non-medical specialists, there is a explicit codified duration for the non-competes, and then that's different for medical specialists. And so the number of days is specified in the law. That's helpful. And there is, as Deontay did cover, more specific language about who qualifies as a DC employee. And so that just helps remove some of the vagaries that were present in the original law. And so I will agree that there are aspects of the law that are clarifications, but I do think calling it a clarification amendment is a little bit deceptive, because it makes it seem as though it is a mere clarification, but it really entirely guts protections for employees across the board. I will also note that some of the provisions that were in the original act that are very important for employees remain relatively unchanged, if not entirely unchanged. I'd have to absolutely read word for word, but employers are still prohibited from retaliating against an employee for refusing to agree to a non-compete, for failing to comply with a non-compete, if that employee, of course, is not required to do so and is protected from participating in a non-compete agreement. Employers cannot retaliate or threaten to do so if the employee asks about their rights or informs a person or entity about a potential violation, or if it requests information from the employer that is required to be provided to the employee. And then the act still defines what retaliation means. It says, this constitutes an adverse action, including a threat, verbal warning, written warning, reduction of work hours, suspension, or termination against one or more employees. So it doesn't necessarily have to be the one who's inquiring if it comes as a retaliation explicitly linked to one employee's protected activity. And there are still consequences for noncompliance. I do not believe there were significant changes to them, but the mayor may collect administrative penalties, and there's a potential involvement of an ALJ, administrative law judge. Employees may bring administrative complaints and civil actions against employers. There are still statutory penalties available. And so there are opportunities for employees to protect the rights that still exist under the Act. And these anti-retaliatory provisions are very important. I don't want to understate that those still remain, and that employees should learn their rights under the law and the protections that are available to them. Because again, as long as the employee is making less than 150,000 in total compensation, the Act as it originally stood still applies to them. Most non-compete agreements, those employees are not required to sign or otherwise participate in.
So, Deontay, what else should employers know about the new provisions in the Clarification Act? How should employers prepare?
Before I answer this question, I'll have to give the same disclaimer I did in the first episode. I'm not providing legal advice. I'm just looking at this law and saying, gee, if this was me, what would I do? And even though I work for Ogletree Deakins, this is my personal opinion. So let me say this without shamelessly plugging myself. I've recently wrote a blog post on this where I will highlight some of the things that we discuss in regards to colleague and I, Jim Murphy, some of the things that employers could do. First and foremost is breathe, right? Unlike the previous law, whereas everything related to non-competes is prohibited, with this particular law, you get to take a time to breathe, right? And then once you do that, you need to identify, more importantly, those individuals who would be considered highly compensated, and make sure that you understand why they are highly compensated. But also, if you actually need to get into a non-compete agreement with that employee, simply because they qualify as a highly compensated employee doesn't necessarily mean that you need to have a non-compete, because remember, you still have to think about the function, the geographic, and the time aspect of it to make sure that it's reasonable under the circumstances. You also need to make sure that you create some kind of guard post to ensure that those individuals who are considered covered employees are not erroneously provided a non-compete provision, and or there's a policy, whether written or unwritten, that's been enforced by managers. So it's important to create a guard post to ensure that covered employees are not negatively impacted, whether intentionally or unintentionally. And as Rachel indicated, she focused on some of the important things about retaliation. I will say, employers don't want to retaliate. Okay. Employers love their employees. And so, you want to create these guard posts to ensure that, you're not stepping across the boundaries, whether intentionally or unintentionally. You also want to make sure that when it comes to the non-competes, particularly for those who qualify, whether it's a medical specialist or a individual who meet the threshold to be considered highly compensated, you want to make sure that you are prepared to give them the required notice, because when you propose a non-compete, that notice need to come with it as well. And also review your workplace policies to ensure that they do not violate the law when it becomes in effect, unless Congress steps in and tells DC they should not enforce it. It's destined to go in place on October 1st. So make sure that you review your policies to make sure that they don't step the boundaries. And if you are going to create a policy based upon one of the reasonable beliefs, make sure you articulate that and be prepared to provide the notices that you need to give to covered employees in regards to that. And the final thing that I would say is, even though this is a clarification to the original law, we all know, I'm sure Rachel will agree with me, here in DC, laws are destined to get change in the sense of how it's interpreted by whatever agency is going to be responsible for enforcing it. I know that this says that the mayor is the one that you'll bring an administrative complaint, but the mayor typically isn't going to deal with this. She's just going to designate some kind of organization or agency to deal with it. So employers should be readily looking for outgoing or incoming, incoming regulations and standards and procedures to make sure that whatever interpretation that particular agency takes with respect to this law, that they are in line with it. And I think Rachel already discussed the penalties, but we know that there are administrative penalties in the law. I think the minimum penalty is $500 and it goes up to $1,000 and $3,000. And then whatever, if you want to, if an employee takes it to trial or a civil action, whatever penalties that the court may so impose. So it's important for employers to make sure they stay in the green light and not cross the yellow or red light.
Thanks, Deontay. Rachel, do you have any last thoughts? I know you already mentioned so many important takeaways for employees to note, but I'd love to get any final thoughts from you.
Thanks, Olive. I'd first start with the same qualification that Deontay started with, is that, I'm not here providing legal advice, and also the opinions shared are not representative of my firm. They are my own opinions. But I do think it's a little bit simpler for employees than for employers who are creating policies and drafting the non-competes. Employees generally, broadly, should learn their rights. They should hopefully be keeping themselves apprised of the changes in the law, and employers are required to notify them. There are certain deadlines and time limits for notifying employees for changes in the policy. Employees do have a right to ask their employer for information if it's not posted or not easily accessible. If an employee is confused about what their total compensation is and whether or not they may or may not qualify for protection from a non-compete under the act, they do have the right to ask their employer for that information. What is my total compensation? Am I eligible? Do I have to sign this? So things like that. Employees generally need to be aware of their rights under these laws, especially with the quickly developing law and how amendments significantly can change the law. And then, as I already mentioned, with the retaliation protection, employees should know that their employer may not retaliate against them or threaten to do so. And they do have access to a variety of civil actions and penalties that they might be able to pursue against an employer. I do not yet have a blog post out, but it is in my queue. And so if employees are interested in learning more, they should check out the Katz Banks Kumin blog post soon. I'll do a shameless plug for that too. But that's all I'll say from the employee side.
Well, thank you both so much for contributing to part 2 of our podcast. It was a pleasure speaking with both of you. The revised law, as we mentioned earlier, was signed by Mayor Bowser and is expected to apply starting October 1st, 2022, barring any opposition from Congress. Thank you for tuning in to part 2 of the two sides to DC's new ban on non-competes on Brief Encounters. And please check out Deontay's blog on Ogletree's website and Rachel's incoming posts on Katz Banks Kumin. Thank you all.
Thank you. And thanks to the DC bar community for putting this on.
Yes, thank you very much.